All right, this is in the matter of Jackson, Ireland, file J25-335-NA. President, what can I have, Mr. Somersfield, if you put your appearance on the record, please.
Thank you, Judge. Good afternoon. John Somersfield for the Department of Health and Human Services.
All right, I do see Ms. Sullivan is here from the department. I also see Father Cody Ireland and Mom Kendall Ireland. Mom and Dad, this is a hearing after an initial petition to place the children in protective custody, or place the child in protective custody that was issued by the court on an ex parte basis last night. So I'm here to tell you what the charges are and to decide where we go from here. Have each of you received a copy of the petition, Mr. Ireland?
Yeah.
Mrs. Ireland?
Your Honor.
I'm sorry, I didn't hear whether you said yes or no.
Yes, Your Honor.
All right, thank you. Do either one of you want me to read that petition to you?
No.
No, thank you.
All right. I would note that Jackson was just recently born. Is that correct, Ms. Sullivan?
Yes, he was born July 7th of this year.
So are you aware of any other courts that he would be subject to the jurisdiction of at this time?
No,
All right. Are you aware of any Native American heritage?
no.
All right. Mr. and Mrs. Ireland, as to the charges that I'm going to talk to you about in just a minute, you have the right to the assistance of an attorney, and we would appoint an attorney for you if you wish to have one. You have the right to have a trial by a judge or by a jury. You have the right to admit or deny the allegations. Mr. Ireland, the petition is requesting that the child be removed from your contact with you and be placed, I believe, Mr. Somersfield, is that correct? Placed with mother? Is that the indication?
Yes, Judge. However, the court is still seeking jurisdiction over mom in the home basis. So we're not removing the child from mom, but we would still have jurisdiction to be able to monitor. That was really the whole issue for this request for removal from dad.
All right. Mr. Ireland, do you understand the allegations made against you and what the requested disposition of the child is?
Yes, and I would like to talk to my attorney about some stuff that was in the petition.
Yep, we're going to give you a chance to do that. We're going to give you a chance to do that. Mrs. Ireland, do you understand the allegations made and the potential disposition regarding you?
Yes, I do, Your Honor.
All right, thank you very much. I'm going to basically adjourn this matter to authorize the petition in the future after the parties have had a chance to consult with their attorneys. We'll appoint attorneys for them. We'll appoint an attorney for Jackson. And then prior to doing that, I wanted to make sure that I take some testimony from Ms. Sullivan regarding the findings to remove the child from the home. Ma'am, would you raise your right hand so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Mr. Somersfield, would you take some testimony from her as to the 5 factors involving removal of a child from the home?
Yes, Judge. Thank you. Ms. Sullivan, can you state your name, please, and spell your last name?
Ann Sullivan, Sullivan.
All right. And how are you employed?
I am a CPS investigator for Otsego County Department of Health and Human Services.
Okay. Did you author this petition for removal of minor child Jackson, Ireland?
Yes, I did.
Okay. And Jackson's parents, who are they?
Kendall, Ireland, and Cody, Ireland.
Okay. And the child, when you filed this petition, it was domiciled in what county?
Otsego.
Okay. So is custody of the child, and this is in relation to Mr. Ireland, does custody with Mr. Ireland present a substantial risk of harm to Jackson's life, physical health, or mental well-being?
Yes, it does. Cody's other children were previously removed from his care and placed in foster care due to several concerns. He's not rectified the barriers that led the children coming into care, and he's not voluntarily participated in services to help rectify those barriers.
All right. Is there any provision of service or other arrangement except removal from dad that is reasonably available to adequately safeguard Jackson from the risk you just described?
There is not.
Okay. Can you give us, really, what was the crux of the matter here? I know there's a previous removal of children for both parents, is that right?
That is correct.
And the court does have jurisdiction over mom by a plea and father after determination at jury trial.
Correct.
Okay. Has mom been, she's been engaging in services for reunification?
She has.
Okay, and what has dad done any services, prior to his adjudication, which was June 6th of 2025?
I know that a referral was made for Catholic Human Services through the foster care case. As of yesterday, to my knowledge, that appointment's not been scheduled for that substance abuse assessment. He does have, a referral was made and he does have an appointment, but not until October for a psychological evaluation. He did say yesterday that he was doing parenting classes over his phone, but I don't have confirmation that any of those were completed or what ones he's completed. And otherwise, there are no services that I'm aware of that he's participated in voluntarily.
So really, mom is further along in services than Cody is at this time.
Correct.
Okay. Is continuing Jackson in the home of dad, is it contrary to the Jackson's welfare?
Yes, it is.
Can you tell us why, please?
Yes. Essentially because Cody has not participated in those services. He's not rectified the barriers that brought the other children into care. And Cody does have a problem with alcohol, and without that substance abuse assessment, it's hard to establish the level of alcoholism that he is experiencing.
Okay, were reasonable efforts made to prevent removal over about the last 11 days?
So reasonable efforts were the foster care, ongoing case services, CPS investigation, and then those referrals that I had previously discussed for the psychological evaluation, the substance abuse assessment, and then he is participating in supervised parenting time.
Okay, and really wasn't, when the child was born, was there a safety plan that was created that, if followed, we probably wouldn't be here right now?
There was, yes.
Can you tell us specifically what was that safety plan involving Jackson and having contact with the parents?
At the time of Jackson's birth, Kendall had requested that a safety plan be put in place that Cody not be alone with Jackson at any time. So we did put that into a safety plan at the time of Jackson's birth.
Okay, and what happened? Did the department discover things that the safety plan wasn't being followed?
Yes, Kendall did report that she was allowing Cody to come to the house so she could nap. She did not realize that that was essentially a violation of that safety plan, as while she was napping, she was not able to properly supervise Cody with the baby.
Okay. And our conditions of custody, Jackson away from dad, is that adequate to safeguard Jackson's health and welfare?
Yes, at this time.
And can you give us a reason, please?
Yes. Essentially, because Cody still has not rectified the barriers that brought the other children into care, he continues to use alcohol to excess, which ultimately hinders his ability to properly provide care for an infant child.
Okay. Judge, I've gone through those factors and we've also gotten into some of the specifics in the petition. I don't have any further questions for Ms. Sullivan.
All right, thank you very much. Mr. Ireland, do you have any questions of Ms. Sullivan?
Yes, I do. The paper I signed down in Grand Rapids, yes, I did sign it saying I would not be left alone. But also, as you just said, I didn't know, she didn't know that she couldn't just take a 15 half-hour nap, and in that area he was sleeping, so I didn't have to do anything. I was just there to help my wife, who just had a C-section and was in so much pain, so much everything, that she had.
Okay, Mr. Ireland, do you have, the question was, do you have a question for this witness? If you want to make a statement in a minute, I'll certainly allow you to do that. But now is the time to ask a question of this witness. Do you have any questions for her?
No, not at this point.
All right, Mrs. Ireland, do you have a question for this witness? Go ahead. Take yourself off mute and you can ask a question.
Did you also, Ms. Sullivan, not make the statement to me that you guys couldn't necessarily enforce that safety plan? And at the time of the home visit, you were also still planning on removing Jackson from Cody without even doing a home visit of his home, because he does have things for Jackson.
Yes, we did have a conversation about the safety plan, and no, I did not do an assessment of Cody's home.
Have
All
you all
right.
seen Cody intoxicated more than just third-party witnesses?
I have not had contact with Cody other than on this hearing during the jury trial and last July. I have not had contact with Cody, so no, I have not seen him intoxicated.
So is there a chance that at Cody's home, if you would have done a home evaluation and you would have seen some of the things that he had, that it might change your determination of the removal of Jackson? Because it seemed like you already had made up your mind.
I will just say that the alcohol use is not the only concern here.
What other concerns do you have besides just the alcohol? Because he just got adjudicated approximately a month ago. So what other concerns do you have besides within the last 30 days? Because Jackson does not pertain to the previous case. So how is he?
Ms. Ireland, you can't keep running on, and you got to ask a question and stop at some point so she can answer it.
Okay, so how does the barriers for the other children roll over onto Jackson when he's only a week old?
Well, that does, given the allegations in the previous removal, at the time that the other children were removed, the other children were much older than what Jackson is now, making Jackson extremely vulnerable. And those barriers still exist at this time.
Any other questions that you have, Ms. Ireland?
No, not at this time.
All right. The court will find that there is a proper reason to have the hearing, that there was a proper petition presented to the court, that there is a need at this time for the parents to have attorney representation. So the court will adjourn the matter for that. The court will also make a finding that there was a proper removal of the child from the control of Mr. Ireland, because there's a substantial risk of harm to the child's life, physical health, or mental well-being for the reasons stated by Ms. Sullivan, that there's no service or other arrangement reasonably available to adequately safeguard the child, because they've tried a safety plan in the past and that was not complied with by the parents. That continuing the child's residence in the home is contrary to the child's welfare for the reasons stated by Ms. Sullivan on the record, and that reasonable efforts were made to prevent or eliminate the need for removal involving the safety plan, which was not followed in this case, and the conditions away from the parent are adequate to safeguard the child's health, because mom has made some progress towards her goals in the services and can adequately take care of the child with in-home services provided by MDHHS. So the court will authorize at this point in-home jurisdiction for MDHHS to monitor the child with mother, and will exclude Mr. Ireland from contact with the child until further court order. I'll get to you in just a minute, Ms. Ireland. I do see your hand up. Mr. Somerfield, is there any other relief that you would request?
Only that the JC 111 advice of rights be sent to the parents.
All right. Ms. Ireland, did you have a question?
Me and Cody were both wanting to make statements before you had ended.
All right.
Judge, I would advise against that. They're probably going to get the same attorneys with the existing case for Chloe and Liliana. I think they should consult with their attorneys first prior to making a statement.
Well,
It's
here's
the petition.
Ms. Ireland, let me just say one thing, and then I will let you make a statement if you wish. Mr. Somerfield is making sure that your rights are protected because you're not represented technically by an attorney in this case yet. He doesn't want you to make any statements that could be used against you in any way in the future. So he's simply pointing out that you need to be careful about what you say. Although I understand your frustration at times with how the system works, Mr. Somerfield is simply looking out for your best interests because if you make a statement on this hearing, it's being recorded and it could be used against you later. So having said that, if you still wish to make a statement, you may do so. Ms. Ireland, you can go first. Mr. Ireland, you can, or you can remain silent and we'll simply appoint attorneys and then you can discuss those things with them. What is your pleasure, ma'am?
So two different parts in the petition are actually messed up verbiage wise. And I have them highlighted. One states that Cody is like the whole petition actually contradicts itself if you were to look at it line by line, as well as one of it states that Cody is adequately able to take care of an infant while under the influence of alcohol. Another part of that petition actually states for the welfare of Jackson for him to remain in Cody's care. So a lot of this petition contradicts itself in a couple different places.
All right, Ms. Ireland, you certainly will be able, with your attorney, to go over the legal requirements of the petition in the future. None of that prevents the court from taking the action that it did today, however. So thank you very much for pointing that out, and I'm sure you'll be able to address that in the future. Mr. Ireland, is there anything else that you wanted to say?
No, Your Honor, I'll wait until my attorney.
All right, and just for both of the parents' purposes, you do have the right to appeal any order removing your child from your care and custody, including the order of today, an initial order of disposition following adjudication, or an order terminating parental rights, or an order, any other final order. If you cannot afford to hire an attorney for an appeal, the court would appoint one for you, and to preserve your right to appeal, you must request the appointment within 21 days of the notice. If the attorney is appointed to represent you, the court will pay the cost of any transcripts, and you may be barred from challenging the assumption of jurisdiction on the removal from your care and custody and appeal if you fail to timely make that appeal. I'll be sending you notice of these advice of rights regarding appeal in the documentation that you're going to receive regarding today's hearing. So we'll set that in the future, and all parties will be receiving the notice and the next court date. That's all for today. Thank you.
One more. I have not got my appeal for the last adjudication.
Then you need to talk to your attorney about that.
Okay.